Everyone. This is Mamta Roy, Executive Committee member of the Lahari Advocates Forum and your MC for the evening. First of all, I would like to extend my warm welcome to everybody who have spared their precious time in joining us and making this talk a success. Lahari Advocates Forum was originally started as a study group in the library of City Civil Court Association, where people of the advocates would join and discuss on various legal topics concerning their day-to-day matters. Eventually, one of the advocates, Mr. PGC Chengappa, proposed an idea and to create this think tank into a trust and named it Lahari, a wave of ideas. That's how the Lahari came into being, and now it is renamed as Lahari Advocates Forum. Now, in India, we have a very famous adage which goes something like this: Yatra naryastu pujyante ramante tatra devataha, which means the gods preside over those places where women are respected or worshipped. Now, when we hear this or listen to this adage, we suddenly think, naturally, we will think about it in a domestic setup. We never think beyond the four walls of a household or a family. However, women is not simply restricted within the four walls of a house. She goes out to work, she contributes to the economy, and she thrives to come up in life. Now that brings to today's topic, an insight on prevention of sexual harassment at workplaces Act. Ms. Kshama Nargund, who has dedicated most of her life towards social works and has worked towards the upliftment and benefit of downtrodden and oppressed section of the society, also chairs several PoSH committee in several companies, and has today graciously agreed to share her knowledge with us. Thank you, ma'am. I would like to now welcome our president. Kindly welcome Mr. Vivekananda, our president.
Thank you, Mamta, for the insight into the topic. At the outset, I, on behalf of the Lahari Advocates Forum, wish all the women a very happy Women's Day. I, on behalf of the Lahari Advocates Forum, welcome the speaker for the session, Ms. Kshama Nargund, Banavati, the speaker for the session. And I also invite all the invitees who have joined us. When women have to grow, we have to make provision for safe, secure, and comfortable environment to work. And for that, we need safe working spaces, for which I'm sure there is a great necessity for the prevention of sexual harassment at workplaces. And I'm really grateful to the speaker for having accepted our invitation to address us on the topic. And I must say that in our executive committee of the Lahari Advocates Forum, we have almost 50% women who contribute a lot towards the programs, who come up with innovative ideas, and who come up with various challenging ideas and programs to be executed by the Lahari Advocates Forum. I must say, the Lahari Advocates Forum till March 2020 was conducting the Chintana Mantana every week. We used to gather together in the fourth floor of the City Civil Court and have an hour's discussion on some important law or legal aspects. Unfortunately, because of the COVID pandemic, we could not continue that. We intend to start that program again in a couple of weeks, and I request all the participants here to join us and support us in our endeavor. I once again welcome the speaker for the session, Ms. Kshama Nargund, Banavati, and I again extend a warm welcome to all the invitees, advocate friends, brothers and sisters, and the media. Thank you.
Thank you for your very kind words, sir. Ladies and gentlemen, kindly welcome Mr. Sharath Aradhya to introduce our speaker for the evening.
Thank you, Mamta, for those kind words. It is indeed my privilege to introduce the speaker for today's session. She graduated from the University Law College, Bangalore. Even as a student, she was brilliant and outstanding. She considers that she is a student of law forever. She is interested in Hindu jurisprudence, psychology, and law. She has experience handling inquiries under prevention of sexual harassment at workplaces. We look forward to an enlightening session. May I now call upon Ms. Kshama Nargund Banavati to address the audience.
Thank you for those kind words. Ratnakara Dhotapadam Himalaya Kiritini Brahmaraja Shradnadhyam Vande Bharata Mataram. Venerating to my mother, the Bharat Mata, to all the mother of everybody here. I see a lot of seniors here and I have absolutely no idea what I would be even sharing. I see a lot of people, Vivekananda sir, Mamata ma'am, Madhvi ji, Meera madam, Geeta Devi madam, many seniors who I have always looked upon to in my life. And currently, to be very honest with all of you, the state of mind at which I am in is like giving a Viva examination. I have been to their, as a student, I have gone to all of their offices. I have pestered them with various moot problems, and they've been extremely kind and they've helped me out at various levels in understanding different law. And today it is practically giving another Viva examination after about 10-12 years. Hoping that the Women's Day turns out to be a very lucky day for me, and I will be able to at least pass to the extent of saying, okay, we haven't wasted time on this student. For all those hours that they have put in upon me. We stand here to come to the topic, of course. We stand here today to understand, in a broad outlook, something called as a gender-based law. Now, we are all advocates here, so all that it requires, to understand the law, all that it requires is some amount of understanding or proficiency in a language, along with some amount of wisdom. So when we put together these things, and if we open a bare act and try and understand, once we get used to the legal jargon, I'm sure all of us will understand. And we are all advocates here, so obviously we have read it. So what I would want to divide, or how I would want to structure my 30 minutes is in this way. About 10 to 12 minutes of basic understanding, just an overview of what the law deals with. And next, another 10 minutes of just about understanding some important judgments, very few, touch and go important judgments. And about 5 minutes of, how difficult it has been for me to convince entrepreneurs and industrialists that it is important to set up an IC. It's important to set up an ICC in your organization. It's, to be very frank, or many organizations have thought and believe that it is an additional cost that the organization is bearing, and it's additional footing. We really don't want to enter into that amount of bureaucracy. Also, is the natural tendency of many organizations that I have spoken to. And the last part would be my doubts about the law in particular, and how the implementation could be done. We have a lot of seniors here, and therefore, whether to make a law successful is its current form, or should I say, the process of evolution that this law has taken, is it enough to finally, look for a success insofar as this legislation is concerned? So I begin with it. basic structures, we know that the law is called Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Now, this is Act number 14 of 2013. Why is this act a little more important? Because it deals with this an issue of sexual harassment in 3 different ways. 1, with respect to prevention. 2, with respect to prohibition. And 3, when it happens, there is also a redressal mechanism that has been given. In the last part of it, I will try and go back to these 3 words: prevention, prohibition, and redressal. Now, very important sections that we need to know. Section 2N speaks of what sexual harassment is. That is definitely something that we have to know. Section 2A speaks of an aggrieved woman. Again, a question that I'm going to deal with, leave to the august audience here. Is it time that it has to be called aggrieved person? I'm just leaving it to the people here. Aggrieved woman. And then we also have, there are various other things. We have district officer, employee, there is workplace, there is an employer, and there is local committee, and there is internal complaints committee, internal committee. And what is important about this act? How is this act a little different from the others? When all the acts have been concentrating on including only the organized sector, this act went a step further and got involved the unorganized sector. Once the unorganized sector comes into picture, is this structure given by the act by itself, is it enough? Will be another question that we may have to answer eventually. Now, moving on to the main aspects of it. Section 3 deals with prevention of sexual harassment. It says it's trying to imbibe certain habits in the people in a workplace where you're trying to say, no woman shall be subjected to any kind of sexual harassment at any workplace. Now, when we use the word at any workplace, it not only involves the workplace as defined in the act, but also allows for an inclusive definition where we will be able to extend. If it means that a person is traveling on work, then that comes within the definition of workplace. That has been understood. It has been interpreted so by our courts. To be specific, it is the Delhi High Court that went ahead and did the interpretation that workplace should not be given a very restricted meaning. It should be given a very expanded meaning. Gaurav Jain's case very clearly speaks of this. Then it says that the following circumstances, among other circumstances, the entire act, when we notice how this act has, tried to improve upon itself or include various things, is by keeping every aspect of it in an inclusive jurisprudence. It says the following circumstances, among other circumstances. Again, it does not restrict itself to these circumstances itself that have been elucidated, but to other circumstances. This again gets defined by the Delhi High Court, and there is an inclusiveness that is taken over. It says, implied and explicit promise of preferential treatment in her employment, implied or explicit threat of detrimental treatment in her employment, implied or explicit threat about her present or future employment status, interference with her work, or creating an intimidating or offensive or hostile work environment for her, or humiliating treatment likely to affect her health or safety. Now, under these circumstances, so when does an act come? It will amount to sexual harassment. I'm not speaking about what sexual harassment is, but an act would amount to sexual harassment or would be deemed, should I adventure to use the word, to be deemed to be considered as sexual harassment if it is backed by any of these things. If her employment is in question, if the future employment is going to be in question, if her present work environment is going to be in question, or if her health and safety is going to be in question. So under all of these circumstances, an act that has been done would amount to sexual harassment. Now, what sexual harassment is? Sexual harassment initially got defined, we know that it emanates from the Vishakha judgment. Vishakha judgment, justices went ahead and defined sexual harassment to be the most inclusive way. And the same, very same definition goes into sexual harassment in 2N, where they include the first part of it. Then we proceed with immediately after the Vishakha. Unfortunately, we took a lot of time to come or to get this into a legislation. After Vishakha, we got this judgment. Vishakha was in the 98. After Vishakha, we got this judgment we got this legislation only in 2013. Now, were we really slow with this when compared to the world? Yes, we were extremely slow when we compare it with the other world. We have instances where the first Sexual Anti-Discrimination Act, which came to be passed in 1918, and we also have the this is the Canadian law that I'm talking about, and we have US, which went ahead and passed. We have 1964, where Australia went ahead and passed these anti-discrimination laws, and all of these laws went ahead and spoke of sexual harassment at workplaces. And they have given more or less the same definitions of workplaces, expanded the workplaces so as to include all the places where a woman may go out for work. Now, in this Sexual Harassment Act, is it necessary that, for a woman to approach the IC or the Internal Complaints Committee? Is it necessary that she has to be an employee? No, it could be a customer who feels harassed. Now, I use the word very consciously, I use the word feels, who feels harassed by an act of an employee, and because she is the customer or because she has entered your workplace, the IC that is constituted by the workplace will still have jurisdiction to try the matter. So why did I use the word feels? Now, very clearly, the sexual harassment as such, when we do not, unless we go by the strict interpretations of the IPC, sexual harassment on a whole will have a varied way of interpretation, because what amounts to harassment to one person may not be true for the other person. But that does not mean just because this is not true with respect to the other person does not make an act any less harassing than another. Now, Delhi High Court again, in Dr. Punita's case, went ahead and said it is important that a complete understanding of the complainant's view needs to be taken. It is not necessary, it cannot be defined as to what amounts to sexual harassment. It's not, if I have to go to the very basics of the definition, it could be anything. I'll just say it could either be verbal, visual, non-verbal, or it could be an activity or any such communication that may amount to, whether it is tactile, any sensory for that matter, tactile, olfactory, anything that may amount to or has a sexual innuendo would come under the definition of sexual harassment. Now, what would amount to sexual harassment to me would be very different to what it would amount to another person. Why does this happen? This happens because of the cultural differences, the upbringing differences. What would be common to one region may not be common to the other region. So this way, in order to give that amount of freedom so that every person would feel safe, this definition was given such an inclusive interpretation. Now, if a person feels, what should we do? Aggrieved woman, I said, when it comes to, now there could be instances where the complainant is unable to approach the IC for various reasons, maybe her health, maybe her state of mind. So does that mean there is a limitation period that she has to come within 90 days, within 3 months? Now, does it mean that the 3 months has to be so strictly interpreted that she comes late or she comes after the limitation period? Is that a good ground for quashing the complaint, for saying that for dismissing the complaint, to be precise? The courts have answered, yes, 3 months is specified, but that does not mean when there are good grounds, then these 3 months should not be considered to be a bar for looking into the complaint itself, for investigating on the complaint itself. And again, in one of the cases in the Kerala High Court, it so happened that the complainant had written, there was no IC that was constituted because the particular organization did not fall within the definition where the IC had to be formed. They did not have more than 10 employees. So at that instance, she wrote to the employer. The employer failed to pass it on to the local committee, LC, and he passed it on after the 5th month of receiving the complaint of the perpetration of the act itself. So at that instance, the court went ahead and said the complainant has actually approached the employer, and therefore question of bar of limitation does not arise in this case. So therefore, though limitation has been specified, it does not say that it has to be looked into, or it should be given a very strict interpretation. Sorry. Thereafter, there was, if we go to section 9 very clearly says that, where instances, there are complainants. Remember that we have an organized sector included in this act. So obviously, when there are instances where the complainant is unable to write, now the complaint has to be in writing. If the complainant is unable to write, then the ICC or the LC can provide, the employer can provide her assistance so that the complaint is written and the complaint is lodged well within the limitation time. Now, care has to be taken with respect to the mindset of the survivor. Now, when a complaint is written, it's absolutely important that when a complainant is disabled from writing in the sense due to health reasons or life and limb situation, then the law allows her heirs to go ahead and lodge a complaint on behalf of her. Now, when you do that on behalf of her, what is pertinent to understand is whether we have understood the complainant's mindset. The courts in these circumstances where the complaint has been lodged by an NGO on behalf of an employee, or by a legal heir or a legal representative, under these circumstances, the court has gone one step ahead and asked the ICs, the Internal Complaints Committee, to find out if the complaint actually reflects the mindset, or is there something that has been added? Because what really matters, or has even been deleted, what really matters is to understand the complainant's mindset at the time of perpetration of the particular action. Next, if we move on to section 10, section 10 speaks of conciliation. Now, why does section 10, or why do you think that section 10 allows for conciliation? Because the first time as a student I read, and when we look at the compounding of offenses in the in CRPC and look back into these, why would you think, the first thing that actually hit me was, why are they even allowing for conciliation? Then, as we go a little deeper into it, the only reason that this conciliation has been allowed to is because of the feel factor. Now, several times it is possible that certain friendly banters or certain gestures inadvertently would have struck to a person as a gesture of sexual innuendo. So under those circumstances, it is enough if a clarification is being given between the two, the survivor and the perpetrator, and if we are able to conciliate the differences between the two, reconcile the differences between the two. But what is the rider that has been put in so far as the conciliation is concerned? That it should not involve any kind of a financial transaction. So no monetary compensation. It wouldn't say that I will pay you so much, so go ahead and take back the complaint. Is not a valid conciliation. Is not a valid reconciliation. So therefore, they not only try and protect the the victim, but also survivor for all the purposes, but also the perpetrator who has committed a particular action in good faith without having an intention to sexually abuse or outrage a woman's modesty. So under these circumstances, Section 10 has its own importance. Then we move on to Section 11. Section 11 says that, I mean, it speaks of how the ICC has to be done and what about LCC. I will quickly go on to the Section 11 is quite self-explanatory. I will not be dealing because it takes a very long time to deal with it. Section 12 speaks of the interim measures that can be given. Again, the interim measures are very simple. Now it says if a woman wants to be transferred, if a woman wants leave during this process, because it's an emotional upheaval by itself, to lodge a complaint would require her to muster a lot of courage. On top of it, she's facing a trial. Now, if she's facing a trial, then she might not want to react. I mean, she might not want to be a part of the same workplace, would want some time for her own self. So it allows that the employer can go ahead and grant her the leave, and ICC can recommend for these interim measures transfer, or it also says any other such measure may be taken by the employer so as to make the woman feel safe. Again, we see that there is inclusivity because the law has not defined everything. We can't say there is nothing to say that this is it, and therefore there is, it allows for various things to be added onto this law. Next, we move on to Section 13. Now, Section 13 also, I will just say, even before I go on to Section 13, under the Section 12 itself, it says, when we give these interim measures, the interim measures shall also be taken into consideration. We also need to look into whether, if there are any other law, I mean, if there is leave that is already left over, then along with that leave, we give her the additional 3 months leave or whatever that she has sought for. Apart from this, Section 15 speaks of determination of compensation. Now, when you determine a compensation, when a particular compensation is determined, what needs to be looked into: the mental trauma that she has undergone, the distress that she has undergone, the loss of career, the medical expenses, the financial status of the person, and the feasibility of the payment. Now, why feasibility of payment? Because the perpetrator, I mean, whether the perpetrator is capable of paying it or not. So therefore, there is feasibility of payment that has that has also been included in the Section 15. Now, Section 16 says go ahead and protect the privacy of the complainant. None of these things, the complaint and the proceedings that have taken place in the ICC, none of these things need to be disclosed. It has to be protected. It cannot be made available for public. This again is to ensure that she feels safe. She's not put into any kind of embarrassment. Neither the perpetrator nor the survivor in this case are put into any kind of embarrassment, and therefore it speaks of protect the privacy. Section 17 says in case there is a violation of this privacy, then what happens? It speaks of the penalty clauses with respect to that. And again, Section 18 speaks of that you can go ahead when ICC comes with, ICC or LC for that matter, comes with its own findings, and the aggrieved person, I mean the one who's not agreeable to that and finds that the IC has not done the right job, can go ahead and appeal to the court. Now, which court? This is another question that has always taken a lot of mental space of the advocates. The law says that in accordance with the service rules, you go ahead on an appeal, and the appeal period is 90 days. So the court also that you go to is in accordance with the rules. Now, if you, if there's with respect to a government body, then there is possibility you go to the administrative tribunal, or if state or central, depending on who it is. And when it comes to the private parties, this is where it has become extremely difficult, especially when it comes to the software companies. Several of them go to the labor courts, and then the labor commissioners have told them that they don't have jurisdiction, and they've sent them back. And then there have been certain instances where the labor commissioners have taken jurisdiction and have gone ahead. But ultimately, presently, the law stands in such a manner that the labor commissioner finally looks into the IC complaints. So they have approached the labor courts, and the matter gets resolved, or the matter is tried, adjudicated in the labor courts with respect to the IC proceedings. Now, I will come to the IC proceedings. How do they happen? The constitution of the IC proceedings. It is absolutely important to get the right constitution. Why do we have to have the right constitution of the IC? Because if the IC or the LC has not been constituted in accordance to what the law prescribes, then the courts have have dismissed that entire report, saying that only for the purposes of non-constitution in the right manner, the report stands nullified. Therefore, now what is absolutely important? It says that an employee who is of the lowest, who has an approachable employee. It's absolutely important that we need to have an approachable employee. Now, an approachable employee of different categories. Not all from the management is expected in the IC committee. Not all outsiders are expected in the IC committee. But what does it say is that we need to have a chairperson. The chairperson could be one, it should be a woman. Then comes, you can have a male member. We need to have an external person, a person. Now, when we say a third person, the person could be from an NGO, but should have worked for the women causes, or should be equipped, or should know about the law. Therefore, your only options here is to have a person from the NGO which is working for the women causes, or have a person who is an advocate. Under both of these circumstances, it is the constitution of an IC committee is considered fair. Majority of them need to be a woman. So out of the 5, it is important that we have 3 of them as women. 1 male is always recommended. There have been certain interpretations where they have said that you can have an all-woman IC committee. But however, for a holistic understanding of a case, it is absolutely important that you have 1 male member in the IC committee. That will give you a better perspective of what happens. How do the proceedings take place? Now, once the complaint comes in writing, it is very important first that within 7 days, a copy of the complaint reaches the accused. Ensure that the copy goes to the accused, because that will again be a ground for dismissing the report. After the complaint has been given within 7 days, the 7 days is absolutely important again. Once it is given, then they will come up with a reply to it. The reply has to be in writing. Exchange the reply with the survivor. Exchange the reply with the survivor, and thereafter the IC or the LC has all the powers of a civil court under the CPC. You can go ahead and summon people. You can go ahead and decide that this evidence is admissible, this is not admissible. Ensure that cross-examination takes place. Ensure that you give an option to the survivor to cross-examine the perpetrator, and the perpetrator, most importantly, the perpetrator to cross-examine the survivor. Let that happen before the IC, let that happen in the presence of the IC, and how many people should be there, for a basic quorum. Minimum 3 people should always be there. Any proceeding that takes place with just 1 person from the IC or with 2 people from the IC is not considered as a valid proceeding. That part of the proceeding will not be accepted by the court. So minimum of 3 people, that quorum should be followed. And it is always good to have one person consistently in all the proceedings, because it is absolutely important. A case of sexual harassment requires a consistent hearing, requires one person to know it in whole. And therefore, especially the third party, I mean, that is the person from an NGO or an advocate, it is imperative that these people attend all the IC meetings, all the IC proceedings happen. Now, when a complaint comes in, the first time the complaint comes in, this happens when it comes to, the proceedings that happen. But if a complaint does not reflect any kind of sexual harassment, then yes, it doesn't fall within the IC's jurisdiction. So you write a reasoned report saying that this does not constitute of a sexual harassment and therefore does not require the sitting of IC. But this needs to be written very clearly with cogent reasonings. Otherwise, the same can get challenged before the courts. I mean, can be appealed against before the courts. Now, what happens with this IC? Once you prepare the report and then you decide that there's sexual harassment that has taken place and you recommend certain things, where does this go to? This goes to the employer. Now, a beautiful thing that has happened in this legislation that needs to be followed by way of rules is that the employer has received the recommendations. It has not bound the employer in any manner to go ahead and act upon it. Now, what does the employer do? Once the preparation of the report has happened, the report is given to the employer. The employer immediately passes it on. The report is not given directly to the perpetrator and the survivor. It's given to the employer, and the employer passes it on. Employer after the meeting, employer here would be the management. They will pass it on to the perpetrator and the survivor. At that instance, the employer will look into the report and go ahead, take action against the perpetrator if need be. Now, under these circumstances, can it also come with compensation? Yes, like I already said, 15 speaks of compensation, 14 allows for compensation, 15 speaks of how compensation has to be determined. So it allows for compensation. How can this compensation be paid? Now, if the employer has decided to continue the perpetrator and the perpetrator has also not decided to resign, usually perpetrators resign after the IC proceedings. But if a situation comes that they have decided to continue. So under those circumstances, the employer can decide that he's going to deduct certain amount from his salary, and that goes in on installment basis to the survivor as compensation. So, or a lump sum is decided when he generally resigns, then a lump sum is decided, that lump sum is handed over as a part of the compensation to the survivor. So this is the general outlook of how the IC takes place. Now, what happens with once the IC takes place? Can the courts go ahead and interfere with the observations made in the IC? Unless, like I already said, certain basic things that have been followed, the courts will generally not interfere on the findings of the IC, because evidence has been recorded, or evidence will be recorded for the first time in IC, and this evidence will hold good if collected, if recorded in accordance with law as prescribed by the Act. These will hold good forever. So there is a judgment again by the Delhi High Court where there is a beautiful, it has been interpreted very clearly that how a review of evidence needs to take place, and when under review, what is the restriction of the court and why the courts cannot interfere with the findings of the IC. There is a case where the IC went ahead and recommended, that's the Apparel Export Promotion Council, where the IC went ahead and recommended, held that sexual harassment had taken place, and thereafter the had even recommended certain punishments on the perpetrator. Further, the perpetrator appealed, and thereafter the High Court held that no, the evidence does not amount to sexual harassment, and therefore it is not. The IC was wrong in interpreting these things in this particular way. The Supreme Court very clearly said you cannot interfere with respect to the findings of the IC because that has been interpreted or that has been recorded in accordance with law. Therefore, question of why is it absolutely important for the IC to follow procedures in the strictest sense is so that you are putting the foundation for the entire proceedings in the IC proceedings for whatever future proceedings that may come in this, as a bedrock. Now, considering that I've almost taken away most of my time on these aspects, I will quickly wind up the basics that I'm doing, that I'm speaking of, and then proceed to the next part of the case. Next part of my presentation. So, like I said, this is one aspect. Now, this next part, when I say, generally when we go to an organization, an upcoming organization, a startup for that matter, we have a lot of, currently if I look at how the markets are functioning, many organizations, the startup consultants, and there are also PoSH consultants who have come up in the markets, and they're doing a fabulous job trying to convince people. What really has stopped them from forming an IC? One is, madam, it might not really happen. When it happens, let us see. Why now itself? Why do we require it now? We don't have many women. We have only 3 women in our factory, ma'am. All of them are men. How many people in our factory? We have 100 people in our factory, but only 3 of them are women. Now, these 3 women, it's okay. They can manage. In case something comes up, we will contact at that point of time. So this is a general tendency. Why is this a general tendency? Because they feel that the moment you have to constitute another body, it requires some amount of additional investment, some trainings for which they'll have to pay. So these aspects have created an inhibition for ICs in the private organizations. Now, there has been a case in the Madhya Pradesh High Court where, because there was no constitution of an IC, the IC was not constituted in this workplace, in this organization. Therefore, Madhya Pradesh High Court went ahead and imposed a penalty on the organization, saying that it is absolutely imperative that every organization constitutes one. And so if you don't constitute, it imposed a penalty of about 50,000. This is Global Health Private Limited case of the Madhya Pradesh High Court. It is how or why is it convenient? Now, what is it that I do when I speak to my, when I speak to the organizations that I approach to? I tell them that IC is not meant just for women safety. It is meant for better productivity of your employees. What happens is, if you are able to create a better interpersonal relationships amongst the employees of your organization, your productivity will increase. Insofar as, so long as you don't have, or your HR does not have major issues about employee mismatch or employee miscommunications, we will be able to concentrate more on employee welfare program. So don't look at IC as mostly a complaint body. When we say internal complaints body, there is suddenly a negativity that comes in. Don't look at IC as a complaint body. Look at IC as something that will promote the welfare. Now, when you provide, the rules also specify that the IC members have to be trained. IC members need to be spoken of about the law, what their powers are, how is it that they have to interact. And they have, the IC members, the names of the IC members, they have 3 years, their tenure is 3 years. Again, that is questionable. So, but their names have to be displayed in very evidently in the office premises. So all of these things. And if there are premises, now another common question that has come to me is, we have 2 premises. So is it okay that we have only one internal complaints committee because it's managed by the same people? No. every premises is required to have its own IC as per law. Why is it so? Because it's important that when we want to complain, then, or when we want to raise an issue, escalate something, it is important that the body be at a very closer distance. I don't have to, the distance of the IC should not deter me from complaining. It needs to be, we need to create an environment, a convenient environment where it is okay that I have an issue, I will go and complain. Nobody is going to stop me, neither the circumstances nor the attitude. So this is the kind of environment that needs to be cultivated in an organization. And the only way that we will be able to do that is by changing the connotation of IC from being a complaints committee to being a welfare committee. Now, when we say welfare committee, I said that IC members have to be trained. At the same time, the law also says that train your employees about PoSH, what constitutes, because certain things without our knowledge we should not do, and therefore it is important that we train the employees. When we train the employees, generally my practice is I don't train only on what the law says or what amounts to sexual harassment. What really needs to be given to an employee of an organization is how is it that two individuals will interact with each other, irrespective of their gender, irrespective of their race, caste, creed, religion, whatever it is. Can two individuals have a healthy professional relationship? And if we are able to give this to the organizations are more than happy to constitute ICs. Yes, it also says, I also recommend and have advised the organizations that I deal with, saying that have your own PoSH policy. Why is it necessary that every organization needs to have its own PoSH policy? We already have the law, and in any case, the law is always, if there is a conflict between the law and the policy, obviously the law is going to sustain. We do know that. But why a policy? That is because now, what amounts to sexual harassment in a software company is very different from the harassment that a woman in a garment factory is facing. What amounts to what the interpretation of or the idea of the employer with respect to sexual harassment in these two organizations is again different. Therefore, when we are training or when we need to, inform or make the employees aware of what sexual harassment is, it is absolutely important that they're able to relate to what the policy speaks. Law could be a very vague thing for them, but if in the policy we are able to create distinctions, saying that don't do this, specifically what is it with respect to a garment factory, how they're going to talk, what they're going to say, what could be the things that they would say. So if we are able to customize things for them, then there is a possibility, I'm not saying that definitely it will happen, there is a possibility that we will be able to habituate people as to what is the accepted behavior in a workplace. In this is the accepted behavior. In a software company, that's the accepted behavior. So this, though the framework of both the policies is still the same, it is important that the organizations have their own policies. The second reason why they should have their own sexual policy is also because they can include the men, specifically in all, irrespective of what kind of organization it has been, or whether they're into manufacturing, trading, softwares, development, building, builders and constructions. I have seen instances where the men have come and questioned, ma'am, this is happening, where is my solution? And if as an employer, I am not able to give them that solution, currently the law is not enough. But that does not stop an employer from giving this solution to them. Therefore, it is imperative that the organizations go ahead and have their own sexual harassment policies as per the PoSH guidelines, which obviously is subservient to the laws, but it can be done in a more holistic way to include the immediate challenges that the organization is facing. Now, for all of this law, like I said, it is a gender-based law. Now, law is too important a subject to be left only to the lawyers or even to the realm of pure thoughts. I mean, pure thought. That's what Friedman says. He says, law is something that every person relates to. So as lawyers, it's not something only for the lawyers. So what makes something a law? When law and society go together, when there is a movement of two, that's when law emanates. Today, we have various disciplines, the social, the anthropological, the behavioral sciences, the statistics, all of them who are studying law in their own lens. But I question myself, is law doing enough to study the other sciences so as to improve itself? Is law trying to understand when a legislation like PoSH, something which deals with interpersonal relationships, did the preparatory work behind PoSH speak of the behavioral sciences? Did it speak of the basic instincts? Have we looked into what the cultural differences of our nation has been? Why is this law not being, we keep saying that, it's not being completely implemented. Why? To my understanding, it is still alien to our understanding. It's still alien to our collective consciousness. Psychology as a subject has taken the subject of law and has interacted with it very seriously since 1961. From the formation of American Psychology Law Association. Law attempts to regulate human behavior in two ways, proscription and prescription. I said I will go back to those three words, prevention, prohibition, and redressal. All of these two things come under these two words, proscription and prescription. Now, I prescribe certain things and I prescribe certain things. Prescribe with respect to prevention and prohibition, and proscribe certain things when it comes to redressal part of it. By proscription, the law enters into the proscription mode when it comes to the redressal part of it. Now, understanding human behavior, basic instincts, and developed beliefs lie more within the province of psychology and anthropology than law per se. But why is it that these disciplines are not being looked into? It needs, there is a constant overlapping that is happening between these two, or between all of these disciplines. But what has happened, what does law actually do is it prescribes certain procedures that alone law can do independently insofar as interpersonal relationships concerned. The other aspects, the merits or the substantive portion that I speak of when it comes to the PoSH or any sexual harassment or anything with respect to women or men, irrespective of that, interpersonal relationships, are more, should I say, comprehensively or can be more scientifically understood if we have a psychological and a social anthropological lens associated to it. Now, what constitutes a sexual offense? What amounts to perpetrating an offense? All of these things can be understood if we are able to understand, like what the court said in Delhi High Court, it is important to understand the mindset of the complainant. Yes, so if it is important to understand the mindset of the complainant, do we require, these interventions of psychology and everything else are happening at a different level post-introduction of the law, post-introduction, post-implementation of a legislation. But can it not happen before? Can we all not put on a jurist cap now and think, can these kinds of interventions not happen prior to the actual framing of the legislations? Now, what does law do? Again, I mean, just to take the last 2 minutes, there are 2 things or 3 things rather when law says that it's going to implement something. It uses either a deterrent mechanism, or it makes things convenient to people, and then says, or it says, it has to create a public sentiment. Studies have shown that when just a simple deterrent mechanism has been implemented in a legislation, it has not been absolutely effective. Like the PoSH for that matter. Yes, it speaks of prevention. Yes, there is some amount of proscription. But ultimately, what is the aim of a law? The aim of the law is to create a habit, is to habituate people to behave in a certain way. It is basically interfering with the collective psyche of the society and trying to bring in something new, saying that what was very common, a lewd joke was very common, or a lewd message was a very common thing, or a message about, a simple message about how wives behave at home, maybe how wives shop a lot. All of these things could be a very simple thing, but is it not important that the society moves a little ahead and moves away from such kinds of things? And is it not the job of law to implement, or rather imbibe, these habits in the society? And if it has to imbibe these habits in the society, studies have shown that having a mere deterrent thing or mere deterrent perspective to law is not enough. So what is enough, or what makes law a little more effective? Some of the psychologists who have studied law, or who try and understand law, have opined that the way to bring in an enforcement would be if we are able to tackle the collective intuition of the society. Now, when we say collective intuition of the society, it means that there needs to be a sentiment that gets created, saying that this is the way it needs to be. This is how, when a majority of them start feeling that, yes, this is the way, then we are going to have all the others also joining in. So the idea of prevention of sexual harassment should enter a majority space in the mindsets of the people, where people adopt the law for following. People accept the law and obey the law out of collective unconsciousness. It should be, and I use the word very specifically, an unconscious and involuntary, because it should be that simple. Following and obeying a person should find it convenient to obey the law. It should be inconvenient to disobey the law, and it should be convenient to obey the law. So if before the framing of the legislation itself, can an interdisciplinary approach be taken? Can a scientific mindset be developed? Can we back it by the numerous studies that have taken place elsewhere? Although I don't recommend that those studies are relevant for the Indian society, because Indian society has its own collective wisdom. Like what ma'am already said, Yatra naryastu pujante ramante tatra devataha. Naryastu has been constrained to domestic, but unfortunately, when we go back to the Hindu jurisprudence, no. The understanding of law, or the understanding of workplaces, understanding of a woman, or yatra, the understanding of yatra was not at all confined to the domestic jurisdiction, the domestic space at all. It was definitely much higher. We find Draupadi, what was she doing? She was the finance minister of Hastinapura. So that's how Indian society has looked into women. So not that I'm definitely not saying that the studies that have been made in the West can be used here, but what I'm saying is that the West is attempting to make these studies in order to get law more acceptable to the collective consciousness of their society. As jurists, can we not enter into the interdisciplinary space, understand the psychology, understand the sociological interpretation, understand the cultural values that our society has imbibed in us, and redefine the legislations or bring out the legislations in such a manner that they are very natural to have emanated from the society? Can we not bring the idea of we the people into all of these legislations? With these questions that I had in mind, I thank all my seniors and Lahari, Anu ma'am, Geeta ma'am, Sumana ma'am, Vivekananda sir, everybody here to have given me an opportunity. Hopefully I have passed in the examinations that Anu ma'am has put forward for me. I would really want to hear from her. Thank you so much.
Thank you for your very in-depth and in detail explanation of the PoSH Act and also sharing your views on this subject, ma'am. You surely stand up to the reputation who says you are the expert on the subject. Thank you very much. I would request all the audience, including the speakers and the executive committee members, to switch on their videos for a minute so that we can take a picture of it and capture the moment for our records. May I please request everyone to switch on their videos only. Now, as we all know, this is an interactive session, and there are a few questions that have come up on the chat. I would request Ms. Madhavi, who is also an executive committee member, and in spite of her busy schedule, working as a independent practitioner and also a government advocate for the Honorable High Court, has agreed to conduct this session for us. Ma'am, kindly take over the podium.
Thank you, Mamta Rai, for handing over the digital podium to me. At the outset, I must say the talk of the Ms. Kshama Nargund was quite elaborate and thought-provoking. In fact, she addressed a lot of issues in her talk. Since the topic is quite huge and vast, in 1 hour would not be sufficient to do the justice. As such, I would now select some questions to be posed to the speaker to address the same. The first question is, there are complaints that the Act is being misused. Is there any means to prevent the misuse of the Act? How can the misuse of the Act to be avoided?
The first level of sieve has always been the ICC. So when the IC or the LC looks into the particular complaint, then obviously whether it falls within the sexual harassment definition or not needs to be adjudged. Whether ICC has jurisdiction to try the matter or not depends on whether it is a sexual harassment case. So if the ICC comes to the conclusion, like I said, it should be a reasoned order. It says it's not sexual harassment. Give a reasoned order and say, okay, ICC does not have jurisdiction on this. Yes, there are malicious complaints. The law also provides for, the law says that when you receive malicious complaints, when you receive forged documents, then the ICC has the power to take action against the complainant. Now, how do we decide whether it is a malicious complaint or not? Just because a complainant was not able to prove her case does not make a complaint malicious. If the complainant has resorted to some kind of cheating or some kind of dishonesty, forgery, created documents, under those circumstances, a complaint can be considered to be false and action can be taken against the complainant as provided by the law. The law also provides for people who come in and give evidence. When people are giving evidence and they give false evidence or they produce a forged document, then ICC has the powers to go ahead, conduct a proceeding. But before taking action, what is important is conduct a proceeding for taking action, before taking action. Give the opportunity to the complainant or the person who has produced given the false evidence, give the opportunity to be heard, conduct a full-fledged proceeding, and thereafter give out reasonings for taking action. And that way, that is one of the ways of tackling false complaints. Apart from that, abuse happens, but law will take its course certain times. I mean, these are the only mechanisms, or should I say limited mechanisms, that law can do in order to prevent things.
Thank you, Ms. Kshama Nargund and Ms. Madhavi Suresh. I know there are many questions that are lurking on the chat, but since we have already run out of time, I would we are cribbing the time, question and answer time, to one question only, which has been already answered. Thank you for your time and giving us such in-depth, and also about the misuse of the ICC proceedings. Now, please join me in welcoming our secretary, who has got about more than 2 decades of experience in this legal profession. He always spreads joy and happiness everywhere he goes. Please welcome Mr. M. Jagdish, our secretary.
Good evening all. Henry Wadsworth said, "Great is the art of beginning, but great is the art of ending." On behalf of Lahari Advocates Forum, I take this opportunity to propose vote of thanks to those who directly and indirectly contributed to this speech on an insight on Prevention of Sexual Harassment Act 2013, organized by our forum. At the outset, I thank our learned sister from the bar, Ms. Kshama Nargund. We are clear on applicability of functions of Prevention of Sexual Harassment Act 2013 with so much content, like we knew now prevention, prohibition, redressal, unorganized sector. You covered various judgments. Now we also know the timeline, 90 days for the appeal, 90 days, where to go, labor court, labor commissioner, then non-constitution of ICC as per the norms, what happens, importance of ICC. Each organization should have own policy and much more. We are all inspired by your great words. Our heartfelt thanks to brothers and sisters in the legal fraternity, guests of the legal fraternity, and other participants for active participation. A special thanks to Ms. Sumana Baliga for coordinating and bringing such an eloquent speaker. Today's Master of Ceremony, Ms. Mamata, role takers, Mr. Sharath, Mrs. Madhavi, our President Vivekananda, for their unflinching support and coordination. With these warm words and kind message, we move to end of today's lecture. To all the incredible women, shine on not just today, but every single day. Once again, happy Women's Day. Thank you very much.